As part of that, and I commend it to the House.
I call Andrew Little.
Thank you, Mr Speaker. I rise to speak on the bail amendment bill, and just an acknowledgement of that last speaker. Just say what a pity that when the House comes together, it is able to come together and talk almost with one voice on a very important measure, a criminal justice measure, a measure that deals with trying to strike the very important balance between the liberty of the individual and the protection of public safety, that a member should rise to try and score cheap political points about criminal justice. The truth is this, is that the only real toughening of our sentencing laws and bail laws and criminal justice happened under the last Labor government. And we have a lot to thank the Honourable Phil Goff for that work, as he himself gave an account of. Until the change of bail laws in 2000, whereas about 500 defendants were denied bail, that increased over the 5 or 6 years following the implementation of that legislation to 1,700. Look at the National Party's change to the bail laws in 2011, and the impact was on 10 people. 10 people were detained who otherwise might have got bail. And then if you have a look at the assessment of the impact of this bill, it is that it will affect possibly around 50 people. But we come from the principle of justice, that if an innocent citizen is harmed or hurt or negatively affected by another citizen committing a crime, when the justice system might, through proper risk assessment and properly managing a previous charge of that offender, and the harm to the innocent citizen might have been prevented, that is still an injustice. So any measure that takes us a step further to ensuring that that sort of injustice doesn't happen is a step worth taking, and that is why, Mr Speaker, we support this bill. Mr Speaker, the way we handle criminal offenders is vital to public safety, and it is the public safety aspect that underpins this legislation that cries out for proper consideration and ultimately for our support. We note and acknowledge, of course, that offenders on bail have either merely been charged or, of course, the situation where they've been convicted but not sentenced. But in those situations where a defendant has simply been charged, is yet to be tried, or to admit the guilt of their offence, then they are entitled ordinarily to a presumption of innocence. However, when we look back over the last few years, the last couple of decades, the reality is there has been an increase in the reported instances of those on bail committing other offences, and in some cases very serious offences. And it would be a neglect of our duty as a Parliament if we did not take note of that and ensure that the courts and the judges did not have the tools to make a proper assessment in a bail application of a defendant that comes before them, a proper assessment of whether they pose a continuing or real risk to the community in terms of further serious harm. Clause 8 of this bill expands the number of offences to which the reverse onus, which originally appeared in the 2000 bill, applies. Murder is somebody charged with murder faces the reverse onus regardless of whether or not they have any previous convictions. That is a sensible balance. Murder is a serious charge, and I think the track record of the New Zealand Police now is that they do not charge until they are satisfied that there is at least a strong prima facie case. And so a judge is entitled, I think, to look at the prima facie evidence and decide whether or not the defendant poses a further risk to the community. And then, of course, other serious offences apply, the reverse onus applies in relation to other serious offences where there have been previous convictions. And in my view, Mr Speaker, that is a good balance to strike in terms of the court exercising its discretion over bail and having the ability to make a proper assessment of the risk posed by a defendant. The new serious offences added by the bill include kidnapping and aggravated robbery and a handful of others as well. In this situation, the defendant must satisfy the judge that they will not commit any other violent offence or pose a danger to any other person. These changes, as I think the Minister correctly pointed out, largely arise out of the Christy Marceau killing and the petition that arose out of that. And I think it pays just to dwell for a moment on the details of that case, because there is no question that was an unspeakable tragedy for the Marceau family to lose their daughter and sister and granddaughter in that way. And the facts known about that case ultimately resulted in the defendant pleading guilty to some kidnapping charges for the first incident and then being found not guilty by reason of insanity for the ultimate act that he committed that took Christy Marceau's life. There is no question that mental health and the defendant's poor mental health played a large part in that offending. And the sequence of events was that the defendant had committed a very serious set of offences when he detained, effectively kidnapped and threatened other serious offences on Christy Marceau. And then when he was arrested, he was detained, denied bail and kept in custody for a period of time because the court was aware and the police knew that his mental health was an issue. And through the detention he had at that time in custody, he had his mental health issues addressed. He was placed on medication. And some weeks later, when he had a subsequent bail application, which at the age that he was at, he was entitled to make, the judge, faced with a call about whether he should be given bail or not, because this was not a defendant who had any previous conviction, the judge made a judgment call that was in accordance with the law at the time. And without wanting to detract at all from the pain and the suffering and the trauma that the Marceau family has felt, there are others who have peddled those events into a case for something other than what appears in this bill. And the truth is that the balance that has been struck in this bill means that were there to be another, and hopefully there will never be another tragic event as that case, the reality is that even under this bill, it is likely that a defendant of the nature who was involved in the Christy Marceau killing would find it difficult, or at least the court would find it difficult, not to grant bail in the circumstances in which that defendant was. That is not about avoiding giving comfort to the New Zealand public at large, but it is a reality about legislation like this drawing an appropriate balance in the criminal justice context. This legislation also puts tighter restrictions on defendants charged with more serious drug crime, and given the prevalence of it and given the prevalence of criminal offending in relation to drugs such as methamphetamine, that is an entirely appropriate path to take. And then finally, the bill deals with improving or making more explicit the management of and the risk assessment associated with the granting of electronic bail. And Mr. Speaker, when it comes down to it, that is what we in this day and age call on the courts to do when they are dealing with offenders. In this modern age, we need the courts to have the confidence to make an appropriate assessment of risk that those defendants, and some are former offenders, they are convicted offenders, the risk that they pose to the community as the judge considers whether or not detention and ongoing detention is an appropriate status for the defendant to face. That poses in judges an enormous responsibility. They are responsible for community safety as much as they are responsible for ensuring the defendant has and can get a fair trial, is not presumed to be guilty before the facts of their charge are properly tried in the court. And this is always a difficult balancing act to achieve. So, sir, on that basis and with those comments, we will support this bill.
I call David Clendon.
Thank you, Mr. Speaker.